Okay. Okay, I think I got bumped off there for a second. Can you guys hear me?
Yes, Your Honor.
All right, can you guys make your announcements for each case and which case you're announcing for?
Brandon McBride and Mark Gravely and Michael Gavito for the movant CC Young in cause numbers DC 22-01735 and DC 22-03163.
Okay, other counsel?
Your Honor, I'm Colby Campbell. I am counsel for the general contractor Hill and Wilkinson and we're named as a party in all of the cases. We're the plaintiff in the main case.
Okay.
Jared Inman here on behalf of Polk Mechanical Company, LLC, and we are the plaintiff in cause number DC-22-03163.
And Your Honor, this is Patrick Mulray. I'm the attorney for Prism Electric.
Okay, I've spotlighted a number of people here on Zoom. Are these all attorneys, the right attorneys for this case?
I believe that's correct.
All right, let's hear the argument on the consolidation.
Okay, very good, Your Honor. Thank you. So I'll give you a little bit of background information. This is a lawsuit that started off initially in terms of its filing with Hill and Wilkinson, a general contractor, suing my client, the owner of a assisted living residential facility, CC Young Memorial Home. So we'll just call them CC Young. And I might refer to the general contractor as HW as we go along. For seeking the balance on a retainage, the last payments that weren't made at the end of a project after it became apparent to my client that there were substantial incomplete parts of the project and massive construction defect defect problems with the project, and a dispute about whether or not the amounts that HW were trying to charge on this guaranteed maximum price contract were appropriate and correct. So basically, what it amounts to is there's a giant dispute between the general contractor and the owner. And in the middle of that dispute, a substantial amount of money, and I don't know the exact number off the top of my head, but I think Michael Gavito can address that if necessary. But it's several $1 million that's been withheld from payment that were never certified for payment by the architect as the project closed out. And in the middle of all that are some subcontractors. So these are parties that have no direct contractual relationship with CC Young. They are subcontractors to HW, and they have not been paid all or some of what they're owed by HW. And so they have filed lawsuits against HW for breach of contract and also attempted to assert material liens rights against CC Young, my client, in these side lawsuits, of which there have been a total of 4. One of them looks like it's been resolved. We're here today on 2 of those that remain currently, and those are the Prism Electric Inc. lawsuit against CC Young and HW, and the Polk Mechanical Company versus CC Young and HW lawsuits. And what they seek to accomplish with these lawsuits is they're looking to get their share of the withheld funds. The way that these lien statutes work, if they give the owner notice that they haven't been paid by the general contractor, the owner is supposed to hold off on paying the general contractor and hold the money to to make sure it's there to pay the subcontractors, which is effectively what's happened. The amount of money being withheld is substantially more than the total of all these subcontractor claims if you add them all up. So the effect is that there's nothing to foreclose on at this point. What there is a dispute about whether or not CC Young has to pay any of that amount to HW. And really, if HW actually owes CC Young some money back on top of that, when all is said and done, to repair all the construction defects and other problems in this project. So what we have here are 4 currently and really 5 with the new lawsuit, but obviously that one's not in front of the court today. 5 different parties fighting over who gets what share of the amount of money that's been withheld in a retainage on a construction project in the midst of a big construction defect lawsuit. So the same issues are going to be litigated.
Let me ask this: are the plaintiff's attorneys here opposed to the consolidation, or what are y'all's thoughts?
Your Honor, this is Pat Mulry on behalf of Prism Electric. We're obviously we don't agree with the contention that there's anything wrong with the work that our client did, but for the purposes of consolidation, we're not opposed to the consolidation, Your Honor.
Mr. Inman or Ms. Campbell?
Same with us, Judge. We didn't file a response to the motion to consolidate. I mean, I would prefer to keep mine separate, just because a lot of the factual stuff, the big problem about the consolidation from my client's point of view is there are going to be a ton of depots and experts that have nothing to do with my client. That's why we initially filed the lawsuit separately, and we're hoping to keep it separate. But we did not file an objection to the consolidation, and at this point, we're fine with it.
Ms. Campbell?
Yes, Your Honor. On behalf of the general contractor, Hill and Wilkinson, we are owed money, and we are really looking for the best way to most quickly get resolution of this in the interest of getting some of those downstream payments made as quickly as possible. So we're not necessarily opposed to the consolidation. We would be opposed to any effect the consolidation would have on moving the new trial date we just agreed to in December of 2022.
I was kind of thinking about that. What was the trial date again?
We are currently set in December of 2022. All the parties who were currently part of the main lawsuit recently agreed to that date. The petition was filed in August of 2020, so we're about 2 years old at this point.
Mr. Inman and Mr. Mulry, what are your thoughts on that?
Judge, I'm not opposed to a relatively quick trial date, but I cannot do that day. We've got a federal court trial set on December 12th that we've been told will definitely go on that date. So I could not do December 12th, but sometime in January, February, that time frame should be fine with me.
Mr. Mulry?
I don't think December is realistic, given that we're just getting pulled into this, and this has been characterized as a big construction defect lawsuit. I've seen expert reports, but we haven't conducted any discovery. In fact, there's not even a pleading on file to date that alleges any defect by my client. So I assume that'll be forthcoming fairly shortly once this consolidation is done. But I see a fair amount of discovery to be done on this. I don't think a December date's probably realistic, unfortunately.
And I'm not ruling on that issue. If there was an agreement, I could, I'd be glad to move it. But if there's not an agreement, then I'll let you guys work all that out. I will consolidate this. Mr. McBride, did you already prepare an order for my?
I didn't, but I will get it over to your court coordinator this afternoon.
So when you do the order, can you make sure, so two things. One, that it says at the beginning, these are both very important, that this was heard on July 18th, 2022, as opposed to on this date. And then if you could get sign off to the opposing counsel, at least as to form. And then have you guys already mediated this case or not?
We have not, Your Honor.
Who's your mediator?
Your Honor, the court had appointed someone. I'll check that person's name.
Well, my guess is we probably have 3 different mediators, and it may be from other judges. I would suggest, although this is not a ruling at this point, but I would suggest you guys consider going to King Pfeiffer. He's kind of an expert in this area. Have you guys used him before, or what are y'all's thoughts?
Your Honor,
not,
I've
Your Honor.
mediated with him before. It wasn't successful, but that wasn't his fault.
Ms. Campbell, what do you think?
I have not mediated with him before, but will certainly run the name by my clients.
Or is there somebody you guys really like? I'd like to get you guys the mediation as soon as possible.
I'll throw out Lee Shidlovsky is a very familiar and very effective mediator for these multi-party construction defect cases involving these types of issues.
Is he or she from Dallas, or where? I've never heard of that person.
He is from Austin. He conducts his mediations, at least up to this day, has been conducting them by Zoom and continuing them by Zoom, and has been fairly effective in resolving these types of cases. I think everyone on this screen has probably used him at some point in the recent past.
Yeah, and Judge, on behalf of Prism, we wouldn't have any problem with that either. I mean, I'd have to run it by my client, but we mediate, and Mark and Michael and I have all mediated together with Lee, I don't know, dozens of times at this point. We wouldn't have any problem with him, I don't think.
Is
It's
everyone-
good.
With us, Your
I'm
Honor.
good schedule.
I'm sorry.
And we actually have Mr. Johnson, he's not popped out, but he's got another motion pending for entry of a scheduling order in this case, because that's been one of the problems. We don't have one.
I'm sorry. What is? Do I not have him spotlighted?
Not yet, Your Honor.
Is that Mark? Is his name Mark on the screen?
Larry Johnson,
Larry Johnson. Okay, sorry.
and he's counsel for D2, the architect in this case. And we actually have another setting for a motion for entry of a scheduling order. And I mentioned that only because it ties directly into what we're talking about here with selection of mediators, and really just the desire to get a scheduling order in place, knowing that we have new parties coming in.
That's set at, I guess, 3:45. I don't
3:45,
mind
yeah.
hearing
Yes,
it
Your Honor.
now if everybody's okay with that.
Yes, Your Honor. Larry Johnson here for D2. I had filed the motion for entry of the scheduling order at the time we filed the motion for continuance. The continuance at the time I filed it was not agreed, but then afterwards it was agreed, but we still don't have a scheduling order. So I just kept this on the court's docket so that we can hopefully try to get some agreement on scheduling. My understanding as of last week was that counsel for Hill and Wilkinson was okay with the proposed scheduling order, but the counsel for CC Young was not. So I think that's, I don't want to misrepresent anything, but I think that's where we were. And I'm happy to go back to the drawing board and try to find something that works for everybody.
What if I did this? What if I put you guys all into a breakout room and you guys try to work out the mediator issue, which sounds like it's about 90% worked out, and then talk about the scheduling conference? I'll send one of my interns in with you, or a couple of my interns in with you, and then they'll tell me when you guys are done. Would that work?
Yes, Your Honor, I think that would work. Especially, I think it would be more beneficial to the group if we knew when our trial date was going to be. Then we could work backwards and get deadlines we could live with.
Well, I'm flexible on when you set the case for trial. When do you want to set it for trial? Do you have an agreed date?
We do not, Your Honor. There was a December date thrown around in light of the additional parties, in light of where we are in discovery. I don't think that's going to work. And then I think once we get the trial date, we can work backwards on deadlines.
Well, when do you guys want to set it? And I can look it up right now and give you a date.
Your Honor, on behalf of Hill and Wilkinson, we're certainly willing to work with the new subcontractors coming in and recognize that there's scheduling conflicts that would prevent us from keeping that December date. We haven't conducted any depositions yet. We've done pretty limited discovery, so the new folks coming in won't be too far behind the curve. But we would ask for something not too far after the current date. So
How
winter
about-
of 2023.
Why don't I give you 3 dates and see if you guys can agree on any of them when I put you in the breakout room. February 14th, 21st. April 4th. Did you get those dates?
Yes, Your Honor.
So why don't you see if any of those days work? I'll put you in the breakout room. I'll send some of my interns with you, and then they'll text me when you're done. I'll bring you back into the room and we can hopefully get this all resolved. Does that work okay for everyone?
Yes, thank you, Your Honor.
Your
Yes,
Honor,
ma'am.
I'm sorry to interrupt. This is Amanda Koch. I'm also counsel for Hill and Wilkinson. Would you mind
Oh,
adding
sure.
me to the breakout room as well?
Let me see. I don't see you. There you are. I would have spotlighted you. There you go. Are you spotlighted now? Anyone
Yes,
else that I'm
thank you.
missing? There's a Mark Gravely. Do I need to add him as well?
Yes, Your Honor.
If you would, please. Thank you, Judge.
How about Lily Graham?
If you could add her as well, Your Honor, she's our summer intern.
Oh, Lily, why don't you turn on your camera? Where do you go to law school?
Unfortunately, my camera is not working, but I actually go to law school at Thurgood Marshall School of Law in Houston.
Oh, well.
At TSU.
Well, welcome. I'll try to add her as well. Why don't I have my interns, you guys all introduce yourself. Tanner, why don't you start?
Hi, everyone. My name is Tanner Wright. I'm a rising 2L at the University of Texas School of Law.
Zoe,
Hi, I'm Zoe. I'm also a rising 2L at UT Law.
Emily,
I'm Emily Olam. I'm a 2L at Baylor Law.
Jamie,
I'm Jamie Mills. I'm also a rising 2L at Baylor.
Andrea,
Hi, everyone. I'm Andrea Herrera. I'm a rising 2L at UT Law.
Zach,
Hello, everybody. My name is Zach. I'm a rising 2L at UT Law.
and Monica.
Hi, everyone. My name is Monica Brown. I'm a rising 2L at UT Law.
All right, I'm going to put Tanner in charge. So Tanner, no rulings, but you're going to supervise these folks. And I'll send you into the breakout room with them, okay? And if for some reason I miss somebody, it's not on purpose, just let me know and I'll add you to the breakout room. But
Judge, can you please add me to the breakout room? This is Reese Wade.
Okay, I will do my best.
Thank you.
So I have Amanda, Brendan McBride, Colby Campbell, Jared Inman, is that right? Jason Irvin, do I send him?
No, Your Honor, I just logged in early for the next hearing in anticipation of technical difficulties, which.
Okay. How about Larry Johnson? I think he's in this, right?
Yes, he is, Your Honor.
Yes, Your Honor.
Lily Graham,
Yes, Your Honor.
Mark Gravely, Michael Gavito, Patrick Mulry is in this one. Reese Wade is in this one, correct?
Not yet, Judge.
Oh, am I supposed to send you to the breakout room?
Yes, please.
Okay. Tanner Wright is going to be my representative, and Whitney Beckworth. Was she the intern?
No, Your Honor, I'm here for the next hearing. I just logged on early as well.
All right. Did I get everybody? And I'll also add Emily Ulam as well. All right, guys. Good luck. And Tanner, text me when they're done, okay? So Rhonda, just real quick, are you there?
I'm here, Judge.
So what's going to be happening is we're consolidating a number of cases into one case on all these cases that are set right now. And then we're going to set them all together for trial. So it was a little complicated. So you should be getting an order in on that within the next day or two. Just make sure you print that out and then put it in my stack. And then all this consolidated case will be what we set for trial.
Okay, is this on the Texart Energy?
No. They didn't show up. I'm not sure why.
Okay, not sure.
It's kind of strange because that took half the time I took reading this was their stuff, but they didn't show up and they didn't let us know. So it's kind of.
Do you want me to contact them?
No, if they didn't show up, I assume they're not. You might want to check. Yeah, I guess contact them just to make sure that they're not like accidentally showed up for trial or showed up for the hearing in person or something. But this case I was just talking about is the DC 2011514 Hill and Wilkinson. That's going to be the consolidated case.
Okay,
So
got it. Okay.
thank you, Rhonda.
You're welcome. Alrighty.
All right, is anyone here on the Blue Racer Midstream LLC versus Pro Car USA case?
Yes, Your Honor. Whitney Beckworth is here for Blue Racer.
Yes, Your Honor. Jason Irvin on behalf of Procarza Tube and Pipe and Procarza USA. My colleague Dean Drew is also here representing Procarza Tubarius. Since they're separate, distinct entities, we'd respectfully ask that the court adjudicate the omnibus motion against all defendants separately as to each defendant.
Okay, let's go on the record on DC 217310 Blue Racer Midstream versus Pro Carsa USA Inc. Counsel, make your appearances.
Whitney Beckworth, and I'm here with Mary Lynn Smitherman as well for plaintiff Blue Racer.
Jason Irvin on behalf of Procarza Tube and Pipe and Procarza USA Inc.
Dean Drew on behalf of Tiberius Procarza SA to CV.
All right, let's proceed.
Your Honor, on behalf of Blue Racer, we're here on two discovery-related issues. Just to give you a little bit of background, Blue Racer filed this suit last June of 2021, seeking damages related to the rupture of a pipe that was purchased for use in a pipeline. That pipe was manufactured and sold by Procarza, or the Procarza defendants. Blue Racer has asserted several claims, including for strict products liability, breach of warranty, negligence, negligent misrepresentation against 5 Procarza entities. Procarza USA and Procarza Tube and Pipe, both of whom have appeared. Tiberius Procarza, who filed a special appearance, and Industrial Procarza and Procarza SA de CV, who have not yet been served. Despite our efforts to obtain documentation over the course of the last year, there's still a lot of confusion as to the roles these different entities served. And we are still facing difficulty obtaining information that was requested in our initial discovery requests to Procarza USA and Procarza Tube and Pipe. And the court previously heard a motion to compel on this same discovery and granted Blue Racer's motion to compel in its entirety back in March of 2022. In addition, Blue Racer has now served jurisdictional discovery on Tiberius Procarza. There's a hearing on the special appearance set for August 8th, and we are experiencing the same type of runaround that we've had with the other Procarza defendants. And so we're here today to address those two issues. And I'll jump in and address the Procarza USA and Tube and Pipe discovery issues first, and then I'll move on to the jurisdictional Tiberius Procarza discovery issues.
Okay.
With respect to Procarza USA and Tube and Pipe, on March 7th, 2022, the court ordered that both of those parties produce documents in response to our request for production, supplement their interrogatory responses, and the court also overruled all of their objections to our requests. While those entities have produced some documents and did supplement some interrogatory answers, the supplementation was not fulsome. And in addition, they have now asserted new objections that they had not previously asserted, which we contend are
they after I ordered all their objections overruled on the same set of discovery, they asserted new objections.
Yes, Your Honor.
Is that true?
Your Honor, we asserted 2 objections. One, because the request said Procarza, not Procarza Tube and Pipe. So we wanted to preserve our right at trial to have the court, should they read in the interrogatory request for reduction, amend that to Procarza Tube and Pipe, because there's 5 Procarza entities here, a multi-defendant case of distinct and separate entities. That's it. No objection that would denote withholding of documents at all. No overbroad, nothing like that. And the second one was to their contingent interrogatories, we reserve the right to supplement, because when we asked for discovery, even the documents referenced in their petition, Blue Racer told us to pound sand. That's it. Nothing that was of nature to withhold documents.
Can you share screen for me any their new objections? Because if that Mr. Urban is telling the truth, I'm not concerned. But if they've asserted new objections after I've overruled all the objections, that's really concerning.
So my recollection, Your Honor, there were new objections based on prematurity and also privilege objections. Those are the two that I recall.
But can you show me what's new and what's old, and I can?
Yes, if you don't mind giving me a second, please, to navigate. Mm-hmm.
Your Honor, I'm going to come over into the driving seat and help Ms. Beckworth get these documents up.
Wait, is someone else speaking?
Yes, this is Mary Lynn Smitherman.
Okay. Just share screen, whatever I need to look at.
Yes, Your Honor, I'm pulling it up right now. Just trying to find one that would be a good exemplar.
If you're really talented at Zoom, you can show me them at the same time, but that is a little challenge. I don't know that I can do that, so I can't criticize you if you can't, but
I would think that might
be good.
Yeah, let me see, I might be able to do that.
It's like advanced sharing options. Does anyone know how to do that? Any of the interns? No, okay.
Able to share my screen with regard to the go. In addition, here for interrogatory number 5, Your Honor, it states this is the procarsa overbroad and imprecise objection Mr. Irvine mentioned previously, which is in this first sentence right here. Apologies, my mouse is a little wonky. As well as interrogatory number 9, you state that there is the interrogatory is premature. And then additionally, 13 asserts a legal conclusion and a privilege work product doctrine objections.
And that was something that was not asserted prior?
That is correct, Your Honor.
Mr. Irvin, if that's the case.
Your Honor, that one slipped through the cracks, but if you look at the first one she showed, it's exactly as I said. The contention interrogatory.
I'm concerned about the second one. You were asserting new objections after I've overruled all the objections.
Your Honor, I believe that's the only one that asserted that particular one, and the only reason that was added is the contention interrogatories asked me to give up evidence related to the basis for our affirmative defenses, but I haven't gotten, for example, the testing documents that they reference in their.
After objections, though, have been overruled, you can't come back in and make new objections. That's not, that's not how it works.
My understanding from the rule, Your Honor, is only that when I produce supplemental responses, that's 192.3, they're timely if I do it at the same time, and the prior objections the court overruled. But that was only in
But
regards.
you have to make objections within 30 days. And then if the court overrules the objections, you don't get to come in and make new objections.
You know, I defer to the court on that particular. My intention for the objections were simply to say, I don't have the documents and I don't want them moving for summary judgment because they've told me that I don't get any of their documents. And so if they told me that, I have nothing to respond with because we weren't part of the testing. So that was my only intention, Your Honor, was to preserve my right to come back. And the only documents I have responsive are my emails to the client, which says, you know, I don't want to go into their content because I don't want to waive that. But that's the only thing that I have is the attorney-client communications or internal work product memos. So I'm really trying to comply with the court's order. I gave them 267 pages, everything I have, as the court asked me to be forthcoming with everything I had. And the contention interrogatories regarding my affirmative defenses are the only ones where I was trying to not commit malpractice by getting all of their affirmative defenses struck in a summary judgment.
Your Honor, if I may respond.
Mr. Urban, I'm not sure. Okay, so if the court has ordered that your objections are overruled, I want to make it clear you don't get to make new objections. That's not how this works. And so if you're still going to continue to try to do that, then we really do need to move on to a show cause. You'll need to have your client here, and we need to talk about, we probably need to do this on a Friday so that we can talk about jail time, because you really seem to be kind of flagrantly disregarding the court's orders here. And I don't know if that's because of you or obviously I don't want to put you in jail, but if it turns out it's you that's flagrantly disregarding it, then I would need to bring a new judge in for the show cause. Well, I guess I could hear it because it wasn't done in front of me, so I probably could. I've never put an attorney in jail. I don't want to do that, but I don't think you're listening to me, and I don't think you're following what I'm trying to say. If I've overruled an objection, you don't get to come back and say, well, I still want to make new objections. You just can't do that. And so I don't know what would be your suggestion, Mr. Urban? Do we need to have an in-person hearing, have your client there and constables there, or what do we need to do here?
Your Honor, I will amend and remove those objections within 24 hours. My intent on the contention interrogatories was very clear, just to preserve my right to bring evidence later. And so that was, I did not withhold anything or any documents.
That doesn't mean, but you don't get to make new objections. That's the issue. You do not get to make, once objections are overruled, you don't get, and you've been ordered to comply, you don't get to I understand if this was at the beginning and you were making objections and you wanted to make those objections before the court had ruled, then I have no problem with that. But once the court has ordered you that the objections are overruled, which as I understand it has happened here, you don't get to say, well, I'm just going to disregard the court's order and continue to make objections.
That was not my intent, Your Honor. As those objections were, look, I'm going to fall on the sword here. I don't want to make excuses. I want to be upfront with the court, and I have reasons but no excuses, and I'll fall on the sword on that, and I will get verified amended responses, removing those objections. We are today filing a new answer, withdrawing the affirmative defenses that we have. I, in fact, tried to do a meet and confer with Ms. Beckworth, where I said, look, I will withdraw all the affirmative defenses if you grant me we stipulate that I can reassert them after I get discovery from them. And so that was my intention, and that was the meet and confer, and the Rule 11 I sent them on Wednesday to try to avoid this hearing was, look, I just want to preserve my right to come back. And so it was not to flaunt the court's ruling or to, to disregard the court's ruling, but the buck stops with me. And so I'll fall on the sword and apologize to the court. That was not my intention at all. And it was simply not to commit malpractice by waiving the affirmative defenses, which I don't know which ones are valid or not, because I haven't gotten, I just got objections to my request for documents from Blue Racer.
Okay. Response?
Yes, Your Honor. I appreciate the direction on the objections. The other issues that we have pertain to the document production and the interrogatory answers, and perhaps Mr. Irvin's amended answer and affirmative defenses will help clear some of the problem as to the interrogatories. And the parties did confer extensively last week and tried to reach an agreement on several issues and just weren't able to. But this was discussed. Part of our problem, our main problem with the interrogatory answers is that we do ask contention interrogatories geared towards Procarsa's affirmative defenses. They asserted 30 some odd affirmative defenses, and it's our position that we should be entitled to the bases for those affirmative defenses. And while I understand discovery is ongoing and parties' claims and defenses, fluctuate during the case, just no response at all at this point in time, it was a little shocking to us. And so we would ask that the court order Procarsa to please provide substantive supplemental responses to those interrogatories. On the document front, Procarsa did produce some documents. We believe that there are key communications that exist that have not been produced, namely between Tube and Pipe and other parties. As it stands, there are no communications that have been produced between Tube and Pipe, which is the entity that purchased the pipe from a manufacturer, which has been represented to us as Industrial, and sold that pipe to a distributor, Steel Professionals, which then sold the pipe to Blue Racer. And there's no communications between Tube and Pipe and Industrial that we have received. The manufacturer of the pipe regarding the order of the pipe, shipment, delivery, and that's just a little bit hard to understand. There's only one purported communication that's been produced between Tube and Pipe and Steel Pros, the distributor, requesting a quote for the pipe. And we would expect to see, response to that, follow up. And so again, we would ask that the court require Procarsa to, provide a full set of documents in response to our requests, which have been pending for almost a year now.
May I respond, Your Honor?
You may.
With respect, Ms. Beckworth's characterization is incorrect in that there are several communications between Industrial and Tube and Pipe that have been produced, 267 pages in precise, which are the invoices from Industrial to Tube and Pipe, and then the invoices from Tube and Pipe to Steel Professionals, as well as email correspondence. Those RFPs were answered without objection, save for the clarification that we are answering as Tube and Pipe, not as Industrial, not as any other defendants. They have deposed, as the court ordered, Tube and Pipe's corporate representative and discussed that at length with him. Those issues never came up. We never got a letter saying there's nothing from that multi-hour deposition that came out where they said, oh, this doesn't show this, or there are these hidden communications. There's a verification and answers without objection to withholding documents that were produced. And so I respectfully disagree with that characterization. And moreover, the basis that they suspect or believe or have a gut feeling that there are additional documents is not a basis for a motion to compel, because as the court's well aware, I'm on a continuing duty to supplement. But what we've done, and after the court's ruling, is we went and found documents and we produced them without objection, without saying beyond the scope or anything like that, and then flew in a representative from Mexico for an in-person deposition as the court required. And for USA, and let me address them, Ms. Beckworth has ironclad documentation that USA didn't exist at the time of the transaction. And she has also deposed the USA rep last week and gotten sworn testimony to back that up, that the company is not related to any other company here. At least there's no corporate relationship in the terms of subsidiaries, parent-child corporation relationship, that they didn't exist and they didn't get any of the assets or liabilities of the other defendants. So I'm confused that they're saying that there's missing documents when they didn't bring this up in the deposition. They didn't bring it up a month after the deposition, happened months ago after the court order. So I don't know what to tell the court. This is all the documents that we have, that we produced without objection of any kind for withholding of documents.
Response?
Yes, Your Honor. Just really quickly, we did depose Tube and Pipe's representative, and he was specifically asked about the email requesting a quote from Steel Pros, and he in fact responded and said, well, why don't we have the email accepting the quote? And so even Tube and Pipe's representative is suggesting that there are other documents out there that we don't have. So it's I think a lot of the problem, big picture, stems from the fact that we have multiple Procarsa entities involved here, and since the beginning there's been a lot of confusion with respect to all of their roles and their involvement with one another. And we have not been provided sufficient information regarding their relationship to be able to discern one way or the other which entity is doing what. And so it's a little bit difficult for us because we're flying blind here. We feel like we've asked for reasonable, relevant documents and have full action.
At this point, I'm not really sure what else I can do. I'm going to order that, again, that all objections are overruled. I'm going to order that any responsive documents are produced within let's say within 5 business days. And then if the defendant fails to comply with this order, then let's say there's going to be subject to a $10,000. Did you guys request sanctions or just show cause?
Yes, Your Honor, we requested sanctions.
So if they fail to comply with this order, then within 5 days, then they'll be subject to a $10,000 as an attorney's fees. I want to give Mr. Urban one last chance, just because I'm not exactly following his logic about why he thought he can continue to object after they've been overruled, but I don't think he's acting in bad faith. And so, Mr. Urban, do you understand the order?
Yes, Your Honor, and I understand. I'm not going to quibble with the court's order. We will comply with the objection to the contention interrogatories with the answering of the contention interrogatories. I would like to, with the court's permission, preserve my objection that says labeling Procarsa, lumping everyone in as Procarsa, because the plaintiffs have over 5 hours. You can distinguish,
Mr. Urban, you can distinguish in your answer which Procarsa entity you're talking about.
We will do that. I just want to make sure that I understand, so that I show the court and prove to the court my good faith intentions. We'll answer the contention interrogatories without objection. We are filing an amended answer today to cull those down to the ones, at least based on our internal investigation, that we can support, with a caveat that we will reserve the right to amend when we've get documents from Blue Racer and our motion to compel.
Of course, you always have the right to supplement if you get additional documents, but I would urge your client, because I just want to tell you, and this is on the record, that if it turns out your document, that your client has documents they have not produced that were in their care, custody, and control, at this point, that they're looking at serious sanctions. And so I would have another heart-to-heart with them and say, look, for example, we have this one email, we don't have the responsive email. We need all of the emails. We need to get this done, or the judge is going to drop the hammer on this, on us, and we need to get this, all these documents produced. And so, because if it comes out later in a subsequent deposition or however, that you're still withholding documents, or your client is still withholding documents, or not doing adequate searches to try to find documents, then you're looking at some serious, given what the other side has done to try to get to this point, just, have a heart-to-heart with them. So, all right, other defendants.
I understand, Your Honor, and I humbly accept and will comply and re-ask and re-urge and follow the court's instructions to the letter. Thank you.
Ms. Beckwith, you just need to give me an order to that effect. Let's go to the next defendant.
Thank you, Your Honor. So the next round of issues pertains to Tuberius Pro Carsa, which filed a special appearance, and that the hearing on the special appearance is currently set for August 8th. Blue Racer served written jurisdictional discovery on Tuberius in May, and subsequently noticed a corporate representative deposition, which was quashed. It's undisputed that Blue Racer is entitled to take discovery on the jurisdictional facts that would either confirm or deny Tuberius's claim that it's not subject to this court's jurisdiction. And to date, Tuberius has produced one document in response to Blue Racer's 30 some odd document requests, and has not substantively answered the vast majority of the interrogatories posed, and largely objects to Blue Racer's discovery on the basis that it's not subject to the court's jurisdiction. But I mean, that's exactly what the discovery is geared at determining. Tuberius, I expect, will come back and say that it has no connection with the state of Texas. And the problem is that to date, Blue Racer has received no clear, reliable information that indicates that, or that explains Tuberius's connection.
Wait. I think opposing counsel just disappeared.
Your Honor, I think he had technical difficulties, so he's going to take the hot seat for me. He came from his office, so
okay.
If that's with the court's permission, I'd like to switch with Mr. Drew.
Sure, no problem.
Apologies for that.
No, I'm sorry, Your Honor. My computer froze and I didn't get to hear any of Ms. Beckwith's.
You just re-entered in the other room, so.
Oh.
Your computer's reiterate for you, so.
All right.
Also, change spots. I need to write your name down again, because you're sitting.
Can you change your name on the screens, sir?
I don't know how to do that.
You want me to do it for you?
Yes, Your Honor. If you have that ability, that would be.
Is it David Dean? Is that what it is?
No, it's Dean Drew, DEAN, last name DREW.
Okay. Is this it?
Yes.
Okay. All right. Go ahead, Mr. Drew.
Your Honor, would you like me to start over, or?
Oh, did you hear it, Mr. Drew, or not?
No, I did not. I heard.
I think essentially she's saying you haven't produced discovery, and you're saying you're not subject to jurisdiction. Obviously, you have to respond to jurisdiction-related discovery. So if there is some type of discovery they've sent you that's not jurisdiction-related, then I need to know. Otherwise, you need to respond to their discovery.
Yes, Your Honor. So, number one, I believe that there's no dispute that Tiberius is not at home under the traditional standard of what's considered at home based on place of incorporation, place of business. So therefore, the jurisdictional discovery that plaintiff is seeking is based on the limited exception of significant contact with the foreign state, and we've made multiple representations to council, and also consistent with our special appearance and our discovery responses that Tiberius was not responsible for manufacturing, selling, or anything related to the pipe of the underlying transaction.
I get that's your argument, but what discovery is there that they've sent you this?
I mean, for example, request for production number 12. It says all contracts and agreements to which you are a party or a beneficiary that identifies the laws of the state of Texas as governing law of the agreement. All invoices, sale orders, lease agreements, receipts, and other documents evidencing all business transactions you've had with any person or entity that maintains a principal place of business in the state of Texas. And interrogatory number 10, have you ever been registered to do business in the state of Texas? Despite our representations, none of these, from a practical standpoint, even if these documents are reproduced or even if they exist, that had no relevance to the underlying facts of the allegations that.
Well, doesn't that go to the issue of minimum contacts?
I understand minimum contacts, Your Honor, but the context has to be so significant with the form state. And
but how is she able to show that? But how is she able to show that if you don't produce discovery?
Well, Your Honor, pursuant to 186.2, I believe in our discovery responses, we've maintained the position that none of these, we have none, like no responsive documents.
Ms. Beckworth?
Yes, Your Honor. This goes back to the issue of not having a clear and reliable information that explains how these Procarsa entities are all related and interconnected. And so I'll use an example for you. We received through Tube and Pipes Production an email from a woman by the name of Giselle Para to a representative of Steel Professionals, the distributor, and it was regarding a quote for the pipe. Ms. Para's email signature block says inside sales, and then Tiberius Procarsa, and then provides a Woodlands address. And so we're left to understand that there's, Ms. Para is an employee of Tiberius Procarsa with an address in the Woodlands. Now, Procarsa has indicated that, Ms. has represented to us that Ms. Para is an employee of Tube and Pipe. Yet Tube and Pipe's corporate representative had no idea who she was, couldn't tell us whether she was an employee of Tube and Pipe, of Tiberius, of another Procarsa entity. And so we're left without, it seems as if the Procarsa entities are asking us to take their word for it. And we've got all this conflicting information. And so we can't assess at this point based on the documentation that we have.
All right, so I'm going to overrule any objections at this point, and I'm going to order these documents to be produced within the next 10 days. And then I think we're talking about continuing the special appearance. Is that correct?
Yes, Your Honor. Just in light of the fact that we're still waiting on documents and whatnot, we would request a continuance of that hearing by at least 60 days, just to give us an opportunity to get those documents, review them, depose a corporate representative on them, and be prepared for the hearing.
Response?
Your Honor, just from a procedural standpoint, in order for a plaintiff to be entitled to a continuance, I believe they have to follow Rule 251, which necessitates a supporting affidavit. And in this case, we don't have a supporting affidavit. And, as I've said already to the court, the document production that Ms. Beckwith believes that Tiberius has, we've already represented that it doesn't. And also, it's, we're not under the rules of procedure. We're not allowed, we're not obligated to create any new documents or, produce documents that we don't have. So I don't, we've made multiple representations to counsel, And through our special appearance and, and the Rule 11 agreement that Mr. Urban referenced earlier, that, we don't have anything that's responsive. And, with respect to, anything that's later discovered, if in fact it is discovered that more documents exist, pursuant to that Rule 11 agreement, if plaintiff agrees to non-suit us, we will agree to toll the statute of limitations for them to bring us back in if it's necessary. So that's all I have, Your Honor.
Your Honor, if I may respond.
Okay.
We don't presently have a Rule 11 agreement in place, just to clarify.
No, I'm sorry, it's the proposed one.
And just to give you an idea of an example of a request that we've made, and I do recognize that the response to this request is none. We've asked for communications between Tubarius and the other Procarsa entities. And it's, they have represented to us that Tubarius licenses a monogram, if you will, to entities including Procarsa Tube and Pipe, which sold this pipe to Steel Pros, which sold the pipe to Blue Racer. And you would expect there to be some sort of communications back and forth confirming that one way or the other. We don't want to have parties involved that shouldn't be involved, but we need confirmation in order to make sure that we do have the right parties involved. And that's truly all we're seeking here.
Your Honor, may I respond to that as well?
Briefly.
Yes, Your Honor. So as I've said before, we've made representations, we've met consistent with our special appearance and our responses to the discovery. If indeed, we don't have them, what further confirmation can we give to plaintiffs to confirm that we don't possess the documents that they're seeking? If what we're
Ms. Beckwith, how does he prove a negative? Ms. Beckwith, how does he prove a negative?
Yes, Your Honor. Well, to start, withdrawing the objections would be a start. And then to the extent that Tubarius could provide us with documentation that in fact confirms that they are not involved with this pipe, thoughts that come to mind would be, financial statements, income statements, things of that nature that would show like, look, we didn't have any money passing back and forth. We're not involved here. I mean, if they can provide us with some confirmation that is of a reliable, documented form, then, we would accept that. But to date, we haven't received anything.
All right. So at this point, I would encourage you guys to kind of talk about this idea of the tolling issue. I think that's probably not a bad idea. I'm going to reset this. Are you guys local or out of town?
Local, Your Honor.
Oh, yes, we're in Fort Worth, so local enough.
Would you guys rather do an in-person hearing on September 9th or a Zoom hearing on September 12th for the special appearance?
Either one will work for Blue Racer.
Do you prefer to do in person or Zoom, Ms. Beckworth? I don't know.
In person would be our preference generally.
Mr. Drew, what about you?
I believe we're available on the 9th because I believe, Judge, you only hold in-person hearings on Fridays, correct?
Correct.
Yep.
Those are subject to trial, just FYI. So if I have a trial setting that carries over, we cancel them. So I don't know if that makes a difference, Ms. Beckworth.
No, it doesn't to us.
Mr. Drew, does that make a difference? Because it could bump us back even farther.
I understand, Your Honor.
All right, September 9th. Rhonda, are you here?
Yes, Judge.
All right, go ahead and reset this special appearance to September 9th at 9 o'clock.
Okay.
And that's on the Blue Racer midstream case. All right, guys, thank you so much. Give me and Ms. Beckworth, when you prepare the orders on this, on all these motions, make sure at the beginning it says this hearing was heard on July 18th, 2022. Share a copy of the order, and I would like to see if you guys can agree to the form of the order. Try to get me that order by Friday, and you guys have a great rest of your week.
Okay, and just to confirm, Your Honor, on the Tiberius issue, what specifically should be included in the order?
So that the objections are all overruled. They need to produce the discovery within the next 10 days.
Okay. Thank you very much, Your Honor.
Thank you, guys. Have a good day.
Thank you, Judge.
All righty. So the folks for the trial setting.
Yes, Your Honor, we've agreed on a trial date of February 21 of 2023. And we also agreed on several other deadlines with one exception, and we hope we can get an agreed DCO. The one thing that we need to come to the court on is the affirmative claim expert deadline. There were some initial drafts of the DCO that were circulated, and at the time when we were still going back and forth with discovery. And so what we're asking for is an extension of the affirmative claim expert deadline from whatever it was, as we were discussing earlier. It was in July, I believe, or June, late June. And now we would just like it to be August 1st. And if absolutely necessary, our expert could get it done by this Friday, but he does have a family vacation.
August 1st is fine.
Okay. There is objection to that, Your Honor. So I'd like them to be heard.
Your Honor, Colby Campbell, counsel for Hill and Wilkinson. We did not have a signed DCO in this case, Your Honor, but we were operating under an agreed scheduling order. We did, all of the parties seeking affirmative relief produced expert reports on June 1st. So the complaint or the dispute here is really that we believe that as it relates to Hill and Wilkinson and CC Young on their affirmative claims, that deadline has passed because we agreed to a date to produce expert reports. CC Young did actually produce several affirmative expert reports and is now seeking to produce another affirmative expert report. And it would be our contention that that deadline has passed already.
Is it true that you're acting, the attorneys for CC Young, is that true that you're acting under an agreed scheduling order?
We had circulated some proposed dates, but we did not get some of the material that we needed, that our expert needed to complete his report. And let me clarify the issue. This is a delay damages expert. There are delay claims on both sides. Hill and Wilkinson's claiming delays. We are also claiming delays. Our expert needed materials and files, that native format scheduling files that were contained in Hill and Wilkinson's files. And they produced a couple 100,000 pages of stuff. But we knew we would get it in their delay damages experts file. And so we got that file on July 5th, and we sent that to Mr. Bay on July 4th. I'm sorry. We sent it to our expert on July 5th, and he says he can finish his report by this Friday or August 1st so that he can do a family vacation. So that's why we're asking for August 1.
Ms. Campbell, I mean, it's a family vacation. It doesn't seem to be any urgency. Are you really going to mess up this guy's family vacation?
Our issue more so, Your Honor, is the fact that we had an agreed deadline to produce expert reports on affirmative claims, and CC Young is making an affirmative claim as to its delay damages. And so therefore, they've now had the benefit of us producing our affirmative expert report on that deadline. And as well as it relates to the files that were requested, if CC Young knew all along it was making an affirmative claim on delay damages, then they should have asked for that information. They didn't ask for that information until after we produced our report, which would have been expected if they were only producing a rebuttal. But this is different. This is an affirmative delay damage claim that they're now making.
It's the same expert, Your Honor. It's not a different expert. It's the delay damages expert was primarily defensive. His primary purpose is evaluating. There's a moving target here of when this project was deemed substantially complete. There's big disagreement among the architect, the general contractor, and the owner. And so in order for him to ascertain when the date of substantial completion was, he needed those scheduling documents. And he got those. He is going to be rebutting the affirmative claims from Hill and Wilkinson, but he's also going to be testifying to, this is the date I believe the project achieves substantial completion based on the schedule. So there was a significant amount of overlap.
But at the end of the day, if you're making an affirmative claim, or if CC Young's making an affirmative claim for liquidated damages, that's a dollar amount that would be an affirmative claim.
All right, I'm gonna go back to what I said before. I'm gonna go ahead and allow this so this guy can go on his vacation to August 1st. Can you include that in the order as well?
Yes, Your Honor, thank you.
All right, anything else, guys? And Rhonda, did you get the trial setting on this?
Yes, I did, Judge.
Okay.
This is on the Hill and Wilkerson versus CC Young, right?
Right, and we're consolidating a bunch of cases into that one, so use that cause number. And did you guys agree to a mediator?
Yes, Your Honor, Lee
Yes, Your Honor.
Shidlovsky.
Who is it?
Lee Shidlovsky.
Spell that.
Yeah, can you spell that?
SHIDLOFSKY.
Mr. Savito, if you could contact Rhonda, my court coordinator, and just let her know, I've never heard of this mediator. And so if you could just let her know what his contact information is so we can include it in our order.
Yes, Your Honor.
All right, guys, thank you so much.
Thank you, Your Honor.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Order. And remember, make sure that the order says at the beginning, July 18, 2022 instead of on this date, but you guys are excused.
Thank you, Your Honor.
Thank you.
Anybody here on, and give me 1 second. I'm gonna be right back. Okay, are both sides here on the Ovilus case? Anybody here on the Ovilus case? Can you guys hear me okay? This Roundsville, can you hear me? Okay. Nobody's here on the Ovilus case, okay. Anyone here on NRA Richard Besner versus REIG?
Your Honor, this is Josh Weems. I'm here for Besner and REIG, Your Honor.
Okay.
Good afternoon, Your Honor. Amy Stewart and LaDouglas Johnson here on behalf of JP Morgan Chase.
Okay. Anyone else here?
Should be it.
All right. Let's go on the record on cause number DC 224275, NRA Richard Besner and REIG Inc. Council, make your appearances.
Yeah, this is Joshua Weems on behalf of Richard Besner and REIG Inc.
Amy Stewart and LaDouglas Johnson here for JP Morgan Chase.
All right, let's proceed.
Your Honor, this is a hearing on a Rule 202 petition. My clients, Richard Besner and REIG Inc., are seeking to take the corporate representative deposition of Chase Bank to investigate possible claims they may have against Chase arising from a transaction that took place earlier this year in January of 2022. A little background on this case. Mr. Besner, individually and as a representative of REIG Inc., was looking to make a financial transaction and investment deal with a Dave Peterson and Newstream Corporation. As part of that transaction, he was going to deposit into Newstream's account $100,000 individually, and then also another $100,000 on behalf of the entity REIG Inc. Email wire instructions were sent to Mr. Besner. Unfortunately, those email instructions were intercepted, and the account was changed from a B1 bank, which is Newstream and Peterson's account, to a Chase Bank account. And Mr. Besner followed the instructions to the Chase Bank account, deposited the total of $200,000. And then it was found that those instructions were incorrect. They had been intercepted, changed, and now Mr. Besner is effectively out $200,000. He's reported this claim to the FBI, gone through their reporting system, has not found any relief through that reporting system for wire fraud. And now our next step is to seek the corporate representative deposition of Chase, see if there are any affirmative claims Besner and REIG Inc. may have against Chase for their handling of this account. And what we're seeking is simply, we're going to seek the corporate representative deposition, specifically regarding affirmative claims they may have, looking to see if they followed their regulations to prevent banking fraud. What were their procedures to open the account? Did they follow those? If the account had closed, what are the procedures for closing that account? Did they follow those procedures? These are some of the topics that we'd like to discuss with Chase to see if this account was handled properly. Did they do everything they needed to do to protect this consumer from fraud? And, if those procedures and policies were in place and they were followed to protect Mr. Besner and REIG Inc. We're not seeking third-party information here. We're seeking information directly for possible claims, to investigate possible claims against Chase. And so this is a difficult situation for Mr. Besner. We're trying to do what we can to help Mr. Besner recover his money if possible. And this is the first step, I believe. And I think the rules will allow for a deposition to determine possible claims against Chase. And I think the benefit to Mr. Besner far outweighs any burden that may be on Chase.
Do we know who intercepted? Is anyone able to figure out who intercepted it, or whose account?
Yes, Your Honor, we do not. We do not know the individual entity or information for the person who opened the account with Chase or who intercepted the email. Unfortunately, this is, these cyber fraud type transactions are difficult to determine who intercepted or changed. He's just an unfortunate victim. So I do not have that information, Your Honor.
All right, Ms. Stewart or Mr. Douglas?
Thank you. I'll proceed. First of all, Your Honor, the first argument we want to make in regard to this Rule 202 evidentiary petition is that it doesn't meet the standard. So Mr. Weems and Mr. Besner were supposed to come to this court with evidence to establish why this deposition is necessary. And if you look at the pleadings, there is no evidence that is attached to the Rule 202 petition at all. And as the court probably knows, in Dallas County, verified pleadings are not competent evidence to support a Rule 202 petition. In addition to that, despite the situation that Mr. Besner finds himself in, and understanding why Mr. Weems needs to make the arguments that he's making, his statements are not evidence either. And so first of all, they miss the entire standard for Rule 202 petition to put forth evidence to establish that the likely benefit of allowing the petitioner to take the requested deposition to investigate a potential claim outweighs the burden or expense of the procedure. And they failed to provide any information or any evidence to support that. Second, they've sought documents. Document production is not allowed under Rule 202, nor did Mr. Weems or Mr. Besner's counsel provide any type of reply brief to the court to establish that it is a right to get documents as a part of a Rule 202 petition. And so the second point is that they don't have any right under Rule 202 to even seek document production in the case. The third point is that basically what's happened here is that instead of just filing a suit against Chase, what Mr. Besner through his counsel is trying to do is do an end run to get an order in discovery in this case regarding what happened with this transaction. Again, we have no evidence before the court that what Mr. Weems is saying is actually accurate. And Mr. Weems also shared with you that he has no idea who intercepted this email, who is a part of this cyber security breach or anything of the sort. He just wants to come to Chase and ask Chase to disclose information that it cannot provide to this court or to Mr. Weems because of federal laws and as well as Texas statutes as well. I mean, think about it, practical, real world. You can't just go to a bank and say, I want all information related to this transaction because we may believe it's fraudulent. But that means none of our confidential information, none of our banking information is safe. And as we set forth in our response, which I won't belabor, we go through at least 3 federal laws that their relief is in violation of. In addition to the Texas Finance Code, that we cannot turn over our account holders' information without them being made aware of this issue. And again, if you go back to the petition, Mr. Besner through Mr. Weems did not identify any other individual or name them as part of this proceeding. So again, they want us to go around and violate federal and state law to provide them the information that they frankly don't have a right to because they never met the burden which Rule 202 requires.
Response?
Your Honor, I'm not asking anyone to violate federal or state law today. I'm just seeking the information that is available to me under 202. I know that in some of the federal laws that were quoted in the response, it says that there should be a referral made to the specific statute while they can't produce the information. I think that's appropriate to make during the deposition, but I don't know that it throws out the deposition itself. Regarding I wish I had the information on the account holder. I wish I did. I wish I knew the name of that person. I don't. But today, what I'm seeking from the court is the ability to discuss with Chase my possible claims, if any, against Chase as a result of this account and the actions taken with this account. I'm not seeking through this specific procedure, even though I would very much like to, the name of the account holder itself. There might be other procedures I can follow to try to get that, but that is not what I'm seeking here today. I'm looking for my claims directly against Chase. This is more of a first party claim instead of seeking information about a third party claim. And I think
let me ask this, is this account currently open, Ms. Stewart, or is it closed, or do you know?
I have no idea about the account. I mean, that's the point, Judge Hoffman. No one understands. No, there's no evidence of what account we're talking about that they have presented to us. What we do know is that I'm not sure if it was Mr. Weems or someone else reached out to Chase, which Mr. Weems forgot to put that part. They contacted the FBI, but they also informed Chase. And when that happened, that started Chase's internal policies of having to investigate these things because he made a fraud claim. And once we start a fraud claim, we cannot then open up the doors of our investigation and provide information outside of doing the investigation that we're supposed to do into the fraud claims. And if there's a deposition we're clearly going to have to disclose and talk about the account and the account holder if that person exists within Chase. So we can't carve out what Mr. Weems wants in his deposition away from the fact that we would have to be specifically talking about this transaction, which we have no authority from the account holder or for the government who holds the privilege to provide that information to Mr. Weems and Mr. Besner.
Then how would he get this? I mean, he obviously needs the information. How would he get it?
Your Honor, I don't know the answer to that, but I know it's not through a Rule 202 petition to Chase that's based on zero evidence other than Mr. Besner found him in this unfortunate situation. Possibly it could be that the investigation has to complete itself. I'm not sure.
Okay. What do you, Mr. Weems, how do you respond to this essentially lack of evidence argument?
Your Honor, unfortunately, I presented what I know about the account itself. It's in the petition regarding the identity of the account, and it's a verified pleading. Now, I understand the argument from counsel regarding the evidence, but I think there's enough here with the verified pleading itself, and I'd ask the court to take notice of as part of the record to support, given this unique factual circumstance, to allow this 202 petition to go forward.
So I understand it. I'm looking at your petition right now.
Yes, sir.
And let me share screen this. It has an ABA routing number and it says
Yes.
XXXX, client accounting number XXXXX. I assume that you provided Ms. Stewart's firm what the actual ABA and client account number are.
I don't know if I was asked. I don't know that I actually provided that to Ms. Stewart's front office. I don't believe that I did.
Well, how are they going to, how did you, I mean, when you opened the fraud investigation, you didn't provide the account number?
Yes, I believe I did when I did the initial, because I'm the one who made the report to Chase and have corresponded with Chase prior to this 202 petition. And I believe I'm going back to my file to confirm that information was communicated, Your Honor. But I don't know that in my conversations with counsel that I've had while this 202 has been pending, I don't know that I've produced that specific information to counsel.
Okay, so there is a 202. I think this is, from an evidentiary standpoint, I think it's okay. It can be verified. It doesn't have to have an affidavit.
Your Honor, quickly, the Dallas courts have stated and rejected the argument that a verified petition constitutes competent evidence in support of a pre-suit deposition alone. I can provide the court with that
provide
citation.
me that, because the rule says the petition must be verified.
Right.
Do you have a Court of Appeals opinion on that?
Yes, it's Henry Dallas County Hospital District.
And this is on a 202?
2014 Westlaw 14-07415 at page 2.
Can you share it? Can you share the case?
Excuse me, I'm sorry.
Can you share screen the case?
I can. Hold on.
Yep.
It's on my other laptop.
And Judge Hoffman, while she's bringing that up, we did provide the routing number and the account number to Chase in our initial demand or our initial correspondence with Chase back in January of this year.
Oops. Sorry, I'm looking for the petition that we sent that had the links in it.
And any of the interns, can one of you guys pull that up and share screen it? Did you guys get can you give them the citation again?
Yes.
This is going to be erased among all the interns. So you can get it share screen first.
It's 214 Westlaw. Here, I'll put it in the chat. It may be easier.
You guys see that? Try to pull that up as quick as you can, and someone share screen it, please. So who shared screened it?
I did, Your Honor.
Is that Monica?
Yes, Your Honor.
All right, let's give Ms. Brown a round of
Good job.
applause.
Good job, Ms. Brown.
What? What'd you say?
I just said good job, Ms. Brown.
All right, good job, Ms. Brown. All right, let's go ahead and let me see it. The 44th, okay. Oh, wow, Carter Stafford, all right. Okay, where in the case are we looking for? What are we?
If you look at asterisk 2,
let's go to
page
asterisk
2.
Is that it?
You know, I think if we search the word verified pleading.
Okay, next.
It's on page, yeah. Are not generally considered competent evidence to prove the facts of the pleading.
Let me see. Look, can you move it up a little bit, Ms. Brown? Okay, go down a little bit. What a strange case. Let's see. All right, how do you distinguish this case?
I believe that's directed to me, Judge Hoffman.
Yes.
And regarding that statement there, Your Honor, I would look the word generally considered competent evidence. These facts I would think are a little bit unique given the evidence and the information that I do have. I think the pleading itself states out in pretty clear detail the facts that happened in this case, the account itself that is established with Chase. And I think there is enough here, while not generally considered competent evidence to prove the facts alleged in the pleadings, I think there is enough here to say that in this instance, it is enough to support a finding from the court to move forward with a Rule 202 petition.
Your Honor, if I can respond, what is the evidence? I mean, what evidence is before the court, which is what the court requires and what the rule requires the court to find. I mean, there's no evidence. It's a verified pleading by Mr. Besner, which is not generally used as competent evidence. And there are Mr. Weems' statements. In this case, those two lines say a verified petition is not enough and the lawyer's arguments are not enough. So what is left that the court is supposed to rely upon as evidence?
And Your Honor, if I can, there's enough in the pleading itself, the verified pleading, to support. And it's regarding the statements that the money was deposited into the Chase account. And so, there's, unfortunately, Chase has not allowed me, or I don't have more information after it's deposited in Chase, what happened with that account. And these are the types of things I would like to investigate. And I know that in some of the cases that were cited by counsel, that this is 202 is an investigatory tool, and there's that necessitates some breadth of pleading and dictates that the courts liberally construe the petition for pre-suit deposition. I'm asking for a little bit of leeway here to investigate the claims, and I think there's sufficient. What we've produced in the 202, the facts alleged there are enough to get us to allow the court to enter an order saying that we can take this deposition.
What case law do you have that says that I can order documents to be produced in a 202?
I'm not seeking documents. I'm just seeking the corporate representative deposition itself, Your Honor.
Your Honor, another consideration for the court is whether what Mr. Weems is asking for outweighs the burden on Chase. So now I'm supposed to prepare Chase to frankly violate law and disclose information regarding an account holder based on no evidence, not even the email that Mr. Weems wrote about in his petition. We don't even have that. All we are doing is relying on Mr. Weems's words. And I'm supposed to prepare a corporate rep for a deposition about a transaction that I've never seen the account information on. And what's going to happen is that we're going to need to seek some type of protection because we cannot violate federal law in response to an order. So that means we would have to mandamus this proceeding, which we don't want to do. So clearly what they're asking for, the likely benefit, doesn't outweigh the burden it is for what Chase will have to go through to get a corporate rep prepared. And before that even happens, having to mandamus this order.
I mean, obviously you have a right to mandamus, Ms. Stewart, if that's what you feel is necessary. And Mr. Weems, are you offering this verified petition in this case?
Yes, Your Honor.
Okay, it's admitted.
Yes.
So, Tony, you're going to need to get a copy of the petition, and it's going to be Exhibit 1 to this hearing. All right, this is what I'm going to order. Subject to, I do want there to be a protection order so that no one outside of this case will be able to see this, because I do agree. I'm concerned with Ms. Stewart is about the identity of the Chase holder, but if they receive the money, they would anyway. So if you go to page 4 of 7 here, there's certain things that are requested. This is what I would allow, and this is what I'm not going to allow. I'm going to allow, you see under 13, there's 6 subpoints. I'm going to allow number 1, 2, 3, and
I miscounted there, Your Honor. I have 3 twice.
Oh, I'm sorry.
That's the first drafting error on my part. I apologize.
the first three.
Okay.
The current status of the funds received by Chase, the disposition of the funds received by Chase, the identity of the Chase account holder. But there needs to be a protective order in place so that none of that is disclosed.
Okay.
And maybe the Court of Appeals is going to disagree with me on this. I don't quite understand that 2014 hearing decision, but the remainder of the request is denied. So if you could go ahead and prepare Mr. Weems a order on this
Yes, Your Honor.
and share it with Ms. Stewart. It needs to say this hearing was heard on July 18, 2022. And anything else we need to chat about today?
No, Your Honor, just for clarification, it's the first three topics that are listed in the verified petition. Okay. Thank you, Your Honor.
And let's say, so to give Ms. Stewart an opportunity, if she decides the mandamus, that we'll have that, the deposition needs to occur within the next 30 days.
How many, Your Honor?
30.
30. Yes, sir.
Anything else, guys?
Thank you, Your Honor.
Thank you, Your Honor.
All right, guys, you guys have a great day, okay?
You too.
Thank you.
All right, bye-bye.